In this segment, we're going to talk about entering your appearance before the immigration court and also how to file documents with the court. I'm Megan Hall. I'm the managing attorney of the detention program at the Rocky Mountain Immigrant Advocacy Network, and with me is my colleague Brittany Hurley, who's a senior staff attorney here at Remain. And she's going to be playing the role of volunteer attorney who has not ever appeared in immigration court before and needs to know what she's doing. I'm going to be playing the role of myself.
Megan, is there anything an attorney needs to do before appearing in immigration court for the first time?
Yes, Brittany, there absolutely is. So, in order to appear before the court, you have to complete a process called e-registry, which sounds scarier and more intimidating than it really is. It's just a very simple two-step process, and you just have to register with the court so the court knows who you are and has some information about you and provides you with an identification number. So the first step in this e-registry process is to create an online profile, and we'll provide links to some of this information, which is pretty detailed, but basically you go online to the Department of Justice's website and go through this e-registry portal, and you just put in some very basic information about yourself, so your name, your date of birth, your bar number, your address, and once you've completed that online profile, you have to go to an immigration court in person to meet with a court administrator who then looks at your photo identification and just confirms that you are who you say you are. So you want to just make sure to plan adequately so that you can complete that second step in the process of going to the court in person before you have to go to court for the first time. And that's what can be tricky if you take a pro bono case with a court date coming right up. The online portion is easy to complete and you can do that at any time. But in order to go to the court and show your ID, it's a really good idea to call the court and talk to one of the clerks or talk with the court administrator just to confirm when somebody is going to be available to meet with you. It has to be one of the court administrators who meets with you and looks at your ID, and so sometimes the administrator is at the immigration court downtown, sometimes he's at the court that's inside the detention center, so you'll just want to talk with someone at the court to figure out when and where you can meet with someone, and you just want to make sure to allow enough time to get that completed. Once you've completed both steps in the process, then you'll get an email indicating that you've registered. It will provide you with an identification number that you have to provide when you enter your appearance with the court.
And are there any exceptions to this requirement? For example, what if an attorney takes a pro bono case but doesn't have time to complete e-registry before the client's next scheduled court date?
That's a good question. So in the government's official frequently asked questions page, which we'll provide a link to, it indicates that judges can make exceptions to this requirement on a case-by-case basis. So for example, if you take a case and there's a hearing the next day and there's no way that you can possibly complete the registry, a judge can basically complete the second step in the process in court. So if you do the online profile, according to the FAQs, a judge can look at your ID and that can all be done in court. As a practical matter, here in Denver, the court administrator has indicated that there aren't exceptions, that all attorneys, including pro bono attorneys, must complete both of these steps before they can appear at a court hearing. So obviously if you take a case from a local nonprofit, we will help you work through this issue, and we've always been able to get it taken care of one way or another. But do be aware that according to the local court, you must complete both steps of the process before you can go to court for the first time.
And once an attorney has completed e-registry, how does she enter her appearance in a case?
So once an attorney has completed e-registry and has that ID number that I was talking about, in order to enter an appearance before the court, the attorney has to file a form called an E-28 form. It's really EOIR, which is Executive Office for Immigration Review 28, but we call it an E-28 form. And traditionally the form is on paper, it's on this light green paper, and we'll provide links to that form so that you can take a look at it. Now, with the advent of e-registry, there are several ways that you can file your entry of appearance. So once you've completed e-registry, you can file the entry of appearance form online through that same portal where you created the e-registry account. So once you have your ID number, everything's set up, you can log in to a part of that website where you can complete forms, and you can fill out this form online and submit it to the court electronically in advance of your first hearing. So that's one option. But I've certainly worked with volunteer attorneys who are having technical difficulties or just can't figure out how to navigate the online system. So you should know that it's still absolutely fine to file a paper version of this form if that is easier for you. So you can print it out and print it on green paper. You don't have to use green paper, but the court strongly prefers that you do. And once you go to court and you see how thick some of these files become, you'll see why. The judge wants to be able to open the file and see that green paper and know that there's an attorney involved in the case. So it is a good idea to use the green paper if you're filing on paper. But you don't have to. You can print on white paper if you don't have any green paper. In a pinch, these forms are available at the court. So you can go to court and fill this out by hand right before your hearing if that's what you need to do. That's not ideal because ideally you want to keep copies of this form. So the best way to do it if you're doing it on paper is to fill it out, have the original ready for the court, make a copy for yourself, make a copy for your client, and then you also have to serve this form on the Department of Homeland Security. And we'll talk a little bit more about that in a minute. But ideally you're not doing this in court the morning of the hearing, but you can, so that's fine. If you e-file this form with the court, one thing that seems to really confuse people is that you still have to serve the form on the Department of Homeland Security. So the attorney who's in court with you, your opposing counsel in immigration court, works for the Office of the Chief Counsel, which is part of the Department of Homeland Security, and we call these people trial attorneys. Anything that you file with the judge, you have to provide a copy to the trial attorney. Any document, and that goes for the entry of appearance, but anything else that you file with the court during the course of the case. And that is not accomplished automatically. So even if you e-file this form with the court, you still have to serve the form on the Department of Homeland Security. That is not done automatically through the e-filing system. So there are several ways that you can get this form to the trial attorney. You can mail it. You can hand it to the trial attorney during court. So if you're going to court for the first time, that's I think what most people probably do. They bring their entry of appearance and they serve it on opposing counsel right there during the first hearing. There's also an e-service option. Now we can serve documents electronically on the Department of Homeland Security, and they have a very detailed instruction sheet for how to do that. We'll provide a link to that. But if you follow those instructions, you can e-serve this form on DHS. In terms of completing this E-28 form, when you take a look at it, I think you'll find that it's pretty self-explanatory. Most of the fields are not all that confusing, but I'll just flag a few things that seem to trip people up. If your client's in detention, you'll want to list the address of the detention center as the client's address, so that it's clear that the client is detained. There's a space on the form for alien number or A number, and that's just your client's immigration case number. So it starts with the letter A and it's followed by 9 digits. There's next to the signature block where you have to sign, there's something asking for your E or ID number, and that's the number you get when you e-register. So we talked about that number, that's what goes in that space. And you have to have that number to fill this out. So even if you're filling it out by hand on paper, you have to have that ID number in order for it to be accepted. One note about your address is if you're taking the case from an agency like Remain or the Colorado Asylum Project, we at Remain at least ask that attorneys do not use our address as their address. It's really important that you have your own address where you can receive correspondence directly, and that correspondence really shouldn't be coming through our office. So obviously if you have a special need, you can talk to us and we can figure something out, but in general you should provide your own address in that space, and if you don't have a business address, you might consider getting a P.O. box for that purpose. On the back of the E-28 form, there's a box where you have to indicate your type of appearance, and if you're taking a pro bono case, you're most likely going to check the little box that says primary attorney or representative. And there's another line where it asks you to indicate whether you're providing pro bono representation, and you should absolutely check the yes box if that's what you're doing. It's really important for the judge to know that you are handling the case pro bono, because the judge is supposed to give you some special consideration in terms of scheduling, flexibility, if the case is a pro bono matter. So make sure to indicate that on the form, and also tell the judge that the first time you go to court. Then the last thing you'll see on the back of, or the second page of the form, is the proof of service. And I've already gone over this, but I'll hit it again just because it's something that seems to really confuse people. You have to get this form to the court, but you also have to get it to your opposing counsel. And the proof of service is confirming that that has been done. So as I said, you can serve this form in person, by mail, by email. And in the proof of service, you should indicate how you're serving the form. So if you are planning to bring a copy of this with you to your first court hearing and give it to the government attorney, you should indicate that on the proof of service. You should say that you're filing it in open court, and you should give the court's address. If you're mailing it, you should say that and indicate the address to which you've mailed it. I think those are the highlights of the E-28 form, which you will file to enter your appearance before the court. If that's not confusing enough, you also have to enter your appearance before the Department of Homeland Security. So there are two parts of entering your appearance in a court case. You have to tell the court that you are representing the client, but you also have to tell the trial attorney using a separate form. And that form is called the G-28. So this is the form that you give to your opposing counsel saying, I am this person's attorney, and you have permission to communicate with me about the case and to release information about the case. So you've got to do both of these forms. The G-28, like the E-28, I think is largely self-explanatory. I don't think it's terribly confusing. It's traditionally printed on blue paper. And again, it's for the same reason. The government attorneys want to be able to flip open their file and see whether an attorney is working on the case. This is a considerably longer form than the E-28. It's about 4 pages long. So if you are confused about anything on the form, check in with us at Remain or your mentors at CAP or Remain to ask any specific questions about how to complete the form. And I will note that your client doesn't have to sign the E-28, the entry of appearance before the court. Only you as the attorney have to sign that. But there is a client signature block on the G-28, so you should try to get your client to sign this. If your client is detained, ICE has indicated that it will accept G-28s that aren't signed by the client, that are only signed by the attorney, if you write detained in the client's signature block. Both of these forms, as you'll notice, are 2-hole punched at the top, and that's an important requirement for any paper filing with the court. And with the G-28, just like with the E-28, there are different ways you can get it to the government attorney. So you can email it to the government. There are instructions about how to do that. You can hand it to them when you go to court for the first time. You can mail it to their office. So those are the steps in entering your appearance before the court.
And what kinds of documents are attorneys typically filing with the court in immigration cases? And what are the methods for filing those documents with the court?
So one thing that is filed in every case is what we've already talked about, the entries of appearance. One thing I want to flag is that the E-28 form, this entry of appearance form, is the only thing that you can file with the court electronically at this point. Unfortunately, the immigration court is way behind other courts and really, frankly, the rest of the world in this respect. They don't accept a lot of electronic filings. The only form right now that you can e-file is the entry of appearance. So don't try to e-file anything else with the court. For all other documents other than the E-28, so that would include applications that you're filing on your client's behalf, documents in support of those applications, any motions that you're filing before the court, all of those things have to be filed in hard copy form with the immigration court. And you can file documents in court during a hearing. You can file documents by bringing them to the court window. And again, it's always useful to call the court clerk and just confirm things before you make a special trip out there, but generally the court accepts filings from about 8 to noon and then 1 to 4. The court does close at 4 o'clock. So if you have a filing deadline, make sure you get to the court before 4 o'clock. You can mail things to the court. You can use regular mail if you don't have a deadline coming up. You can use FedEx, you can use a courier. If you are not filing something in person, it's really important that you still obtain proof that you filed a document. So if you're bringing something to the court window or filing it in court, you should ask one of the clerks to timestamp your copy of the document as proof that you filed it. If you're mailing it in, you can still ask them to do that, but you should send them a self-addressed stamped envelope and ask them to send that back to you. So just remember that the court is behind the times. The general rule is you have to file hard copies of things with the court, in person at the court window, in court, or by mail, in compliance with all the deadlines that apply in your case.
And how should court filings be formatted?
Good question, and this is also a very good place for me to mention the Immigration Court Practice Manual. So if you are working on an immigration case, you have to read the Immigration Court Practice Manual. And you don't have to read it cover to cover, it's quite lengthy, but you should consult with it and be familiar with it because it is incredibly detailed. It explains everything that goes on in court in great detail. It explains what happens during different types of hearings. It explains how filing deadlines are set, but it also explains in a lot of detail the format, the proper format for filing documents with the court. So watching this brief segment is not a substitute for reading the practice manual, but I'll try to just hit some of the highlights, the big picture things that you absolutely need to know when you're filing something with the court. So I have a sample filing here, and we'll provide a link to this so that you can actually take a closer look at it. But all documents you're filing with the court have to be 2-hole punched at the top. Like I said, the court is kind of stuck in an earlier era. Everything's done on paper. The clerks have to file everything in physical files, and so they want everything 2-hole punched so that they can file things easily. And documents will be rejected if they are not 2-hole punched. So you need to buy or find access to a 2-hole punch if you don't have one already. There is actually one available at the court if that is an issue for you, but just make sure you hole punch things. Every filing needs to include a cover page, and the practice manual explains exactly what that page should look like. There's a sample cover page in the practice manual. It basically is like a caption. So it has your address, it says who the client is, the client's case number, and then what you're filing. Every filing has to include a proof of service, which we talked about for the entry of appearance. So every time you file something with the court, you must serve it on opposing counsel, and you have to certify that you did that. So the last page of any filing should be the certificate of service. You have to put page numbers on all filings, and they should be in the bottom corner. And you can just write them in by hand. That's what we do here at Romaine. We don't have anything fancier, and I think that's what most of the trial attorneys do too, but certainly you can bait stamp them or run them through a copier. You can do it a fancier way, but you can just handwrite the numbers on the pages, but they must be paginated. And then finally, all filings should be tabbed along the bottom. So you'll include an index, which is another requirement, which labels all the proposed exhibits using letters, and then you'll tab the exhibits accordingly. A few local preferences to be aware of. So even if you read the practice manual, there are some local quirks that aren't reflected in the practice manual. And one of those is with the tabs. So I think the manual says that the tabs are to be on the right side of the filing, but the clerks here want them along the bottom. So put your tabs on the bottom. The practice manual talks about including proposed orders when you file a motion. So if you're filing a motion to continue a case, the practice manual says that you should prepare the order for the judge to sign. The judges here don't want those proposed orders, and so you shouldn't file them. But if you're practicing in another jurisdiction, if you're filing a motion with another immigration court, it's always a good idea to call that court and talk to the clerk there about what their preferences are. And I think that's just a good general rule about practicing before the court. You should make use of the clerks. Most of the clerks here in Denver are extremely knowledgeable people who have been working with the court for years. And most of them, if you're courteous and polite and considerate of their time, are more than willing to answer your questions and to help you, especially if you are just honest that you're a pro bono attorney and you've never done this before. So when in doubt, talk to the clerk, especially if you're not sure about some of these local issues that I'm describing right now. In terms of how to put the filing together, so you may have a filing that's like 300 pages long. So it's a good idea to attach all those pages somehow, right? So they're not flying all over the place. The local clerks have asked that attorneys don't use those ACO fasteners with the prongs because then they have to take them out, and that just is another step for them. So they've asked us to staple things together. And if you have 200 pages, you obviously probably can't staple that all together. So they've asked us to break the filing down into like 1-inch segments and to staple all the segments together. And then you can rubber band the whole thing together. You can use a binder clip. And some attorneys put separate cover pages on each of those 1-inch segments, indicating which case it belongs to in case those segments become separated. So don't use the ACO fasteners, staple things, and then put them all together somehow. So those are just, like I said, the high points about how to file things. Make sure you actually read the practice manual and follow it carefully, because your filings will be rejected if you don't follow the rules in the practice manual. And if you're on a tight deadline, that could really jeopardize your client's case. So you do have to be really detail-oriented when you're filing with the court.
And other than filing the documents with the court, is there anything else the attorney needs to do with them?
Yes, absolutely. So the first thing, which I've already talked about a couple times, but it's really critical, is service on the Department of Homeland Security. It is not enough just to file something with the court. To perfect the filing, you have to serve those documents on the Department of Homeland Security, and you are certifying to the court that that's what you are doing when you sign the certificate of service. So anything you're filing with the court, a copy goes to DHS. And you have to think about it from a practical standpoint. The trial attorney needs to know what the judge has and what you're referring to when you go to court. And the only way that's going to happen is if you provide them with a copy. And the same thing goes for them. If they are filing documents with the court, they have to serve those documents on you. So you don't want to get into court and have the trial attorney saying, I don't know what Ms. Hall is talking about. She's referencing this 300-page filing. I never received it. They need everything. Everyone needs to be prepared and to have the same documents in their file. So service on DHS, and we talked about how you can do that in court, you can do it by mail, and you can also do it electronically following DHS's rules for e-filing. I believe the page limit on an e-filing is 50 pages. So if you have a huge filing, you can't use the e-service, but for other things you can. So you've got to serve the documents on the Department of Homeland Security. You should provide copies to your client of everything that you are filing in the case. That's a good practice. As you go along, just provide copies of everything to the client. This serves a couple of purposes. First of all, you're keeping your client well informed about what's going on in the case. They'll have everything and they can look at it if they can read in English. If they can't, you can go over with them what it is that you're filing. And then they have everything. It makes them, I think, feel a little more empowered and informed and part of what you're doing for them. It's a good idea because at some point you'll probably have to provide your client with a complete copy of the file anyway, either at the conclusion of the case or if representation terminates before everything is done in the case, say the client hires another attorney and needs everything, it's good to know that you've given the client already those critical documents. So whenever you prepare a filing, go ahead and give copies to your client. When I'm preparing a filing with the court, I just make 4 piles, right? So I make one for the court, one for the Department of Homeland Security, one for my client, and then obviously you want to keep copies of everything in your file. And then the last thing to think about, in addition to filing something with the court, is something called feeing in an application. So this only pertains to applications for relief that you're filing with the court. So that would be like an asylum application, an application for cancellation of removal. In addition to filing the form with the court, you also have to complete this feeing in process, which is a little bit complicated, and we have very detailed written instructions about this. But just to give an overview, some types of applications have filing fees associated with them, which is where this term feeing in comes from. So if you're filing an application for cancellation of removal for permanent residence, the government filing fee, their charge just to accept the application, is $100. Then there's also an $85 fee for biometrics, which is basically fingerprints. So in general, you either have to pay that money or you have to ask for those fees to be waived. The court can't take money. The immigration court doesn't have any way to process payments. So for that reason, everything, all the fees get routed through USCIS, U.S. Citizenship and Immigration Services. So if you're filing an application that has a fee associated with it, in addition to giving it to the judge, you have to send it to a USCIS service center where they can take the money and generate a receipt notice and also generate a biometrics notice, a fingerprinting notice. Now, if your client can't afford to pay the fees, which is often the case with detained clients who oftentimes are indigent, you can ask the judge to waive the filing fee. So you write up a motion asking for a waiver of the filing fee. You include information about your client's finances, and most of the time in detained cases, those are granted. So then instead of sending money to USCIS, you send the judge's order showing that the filing fee has been waived. If your client prefers to just pay or can pay, then you can send a money order. So there are these very detailed instructions for how to do this, but basically you're sending a copy of the application, copies of some other document to USCIS with either money or something indicating that the filing fee has been waived. The judge cannot waive a biometrics fee. So that $85 that pays for the fingerprinting, the judge can't waive that because that's not a court fee. So generally we ask our clients to pay that fee, but there is a separate fee waiver procedure. You can ask USCIS to waive that fee if they really can't come up with the $85. Now, an asylum application doesn't have any fees associated with it, but you still have to fee it in. So you're not really doing anything with fees or money, but you still have to send the application to a service center so that they can give you a receipt and so that they can set up this biometrics appointment. Biometrics sounds very high-tech, but really all it is your client goes to a place, has fingerprints taken, has a photograph taken, gives an electronic signature. And the government uses that information to run a background check. And that background check has to be done before the immigration judge can issue a decision in the case. So like with everything else in immigration court, details are really important. If you forget to do this biometric step, your client is not going to be getting a decision. You could have a 4-hour-long hearing and the judge could be ready to rule, and the judge can't until the biometrics are clear generally. So make sure that you don't forget about biometrics. Follow the instructions that the trial attorney will give you in court about how to do all of this, but certainly don't forget to do it. So the bottom line is, usually just giving things to the court is not enough. You have to also complete all these other steps that we just talked about. Service on DHS, giving copies to your client and keeping copies for yourself. And then for any application you're filing, remember to fee in the application to trigger the biometrics process.